Appeal dismissed.
I think also I meant to mention for listing of one IAL also in connection with criminal when after vacation really deep level. Which liberty to approach appropriate form.
Why? What is this?
My lord, response number is the husband file divorce case, and wife is the APR and file card retention counter claim under protection of under domestic violence. But the
Under?
Protection of women from domestic violence.
Okay.
But family court has dismissed their counter claim on the ground that family court has no jurisdiction. So I seen being agreed, the applicant has filed the appeal on the said imping order.
So what is the appropriate forum?
My lord, file in CGM court.
Huh?
We will file CGM court. Judicial. Chief Judicial Magistrate.
Okay, right. Mr.
TLA.
Tiali, then counsel for the appellant is that he will be allowed to withdraw the appeal to find the same before the appropriate forum. President, the appeal is dismissed as withdrawn, with liberty.
Obliged.
Appellant is present along with Ms. Bibuya, learned AP. This court had directed DNA profiling / test to be conducted upon the appellant and the child by the learned child. The
Archie file person.
I think no. No. Service you have already done service.
Poxo level.
Yes, so
Poxo.
Like
But R2 wants to file.
what written objection have you got to file? What are you going to file?
On her complaint, I'm already behind bars for 3 years. That's it.
Array, a PPS file, you follow that, that's all. What more do you want? Oh, objection to you can have, madam. We would be very, very surprised if you did not have objection. Okay, right. In the IA, Ms. Bibuya submits that
Instruction of
WO has been filed. Not filed.
copy is here, but I have not gone through the records, your lordship. It's filed by Miss S.H. Bora.
Has not been received. Has not been received.
Oh, that's a different
This is
one.
of 7-1.
I've also received a copy. I haven't got a copy.
The problem is that then why don't you two have a consultation outside? We will be out of it. We don't have a copy, no.
Oh, I'm very sorry. I didn't know.
Swapnala Kobole, obvious.
This is the
My
copy
apologies.
is not dated 7 January.
I know.
It is back. It says that
My-
not been received.
Swapnala.
Okay, right. Ms. Bibuya, APP submits that written objection has been served upon the counsel for the appellant. However, the office note dated 7/1/26 states that a written objection has not been received by the concerned section till date. Ms. Bibuya shall verify the reason as to why the written objection to the application under section 430 BNSS has not been received by the registry till it. List the matter on riveting, huh? Then in the main appeal, you write, paper book has been made, correct?
Yes, we received it. By some.
Paper book has been made and Mr. D. Bhattacharya, learned counsel for the appellant, and Ms. B. Buyan, APP submits that they have received copies of the receipt. This is the matter on.
Not want to pay more. He says 11th March. Can I pay it sometime in February?
Give February. We can do it now also. What is it?
I can. If you're also good.
What is that? For Poxo case.
She wants to file objection. We have, I don't know.
Going to file.
Lordship, let the objection be on record, then the matter be taken up.
It'll come in the meantime.
Whether they filed or not, because copy is here.
No, if the paper book is there, we can dispose of
Oh,
the main
yes.
matters. That's all. Give us the paper.
I'll take my chance, brother.
Please, Varna.
One thing. Since there's some hitch, let it be in the early part of February. That will settle.
Immediately after the holidays.
Yes.
You have been given a copy of the paper book?
Paisa nahi. Paper book?
Okay, right.
Spring week it
Okay.
will be taken up after the holidays.
RB Bora also submits that paper book has been received. Coming week, so none of us are going to come here.
No, after the view holidays. Reopening. I will not.
This is the matter on given.
Please study. To wait
28 one.
for hearing.
Obliged, no, deeply obliged.
Yeah, please, Your Lordship. Lordship, this is that case, Your Lordship might remember. One judgment, two cases. Lordship, two cases were there, but one judgment were the
Judgment.
that one, Lordship.
And evidence was taken in both the cases or one case?
No, only one case.
Lordship, both the cases, but some
No,
some
I
evidences were
think
relied.
the evidences given in the cross case has not been taken into account.
Achha, evidence was taken separately.
Lordship. But Lordship has already
The entire thing was decided
Yes.
by way of a common judgment by taking the evidence of both the cases.
Yes, Lordship,
Lordship,
that
can
is.
you have a look? Hurriedly, I have gone to, I have. I might
Lordship,
have missed.
what had happened, Lordship, he is behind 7 years, 10 months, Lordship.
Not on that. So,
Lordship, here,
so the basic facts of the case is that since it is a common judgment and order pertaining to two different cases,
yes.
correct? Cross
Yes,
cases.
yes.
Cross cases.
Mm.
By using the evidence recorded in both the cases.
Maybe in one case.
Both the cases, Lordship.
Huh? So
That
the,
case, that consider Quran hai.
No,
Lordship,
Page number
ordered in 18/3/2024.
no, I am not on that.
Yes.
Please don't ask me to read. Please, you have got to tell me the facts.
Oh, yes. It will suffice to mention that two sessions cases were tried together and a common judgment was delivered. But in the process, reliance is placed on the evidence laid in both the cases. Therefore, this court had arrived at a conclusion.
So that impugned judgment and order is wrong.
Yes.
It's not sustainable.
Lordship.
Correct, because in these type of cases, you have got to have separate evidences recorded.
Separate evidence.
And separate, and that particular case will have to be decided on the basis of the evidence recorded in that
That
case.
particular
Correct.
case, yes.
So, this appeal is against the conviction
Lordship.
in one of the cases.
Yes.
Lordship. They,
And so the conviction has to go. The impugned judgment has to go.
Lordship.
It has to be retried, reheard again
Lordship.
on the basis of the evidence recorded in that particular
One
case.
particular
One particular
judgment.
case, and we can also say that they can have further evidence recorded if they want. Supposing it missed out
Yes.
because they're relying on the other. So we can give them chance to have a thing. But I think there was acquittal.
Yes. So
Lordship.
I have gone through the records. Here, notice was issued on 8/12/2000. Lordship may not have to look into the office note. 8/12/2000 notice issued. 6/1/2020 SR not received back. But my learned friend is appearing for two persons, right? I am for the informer. Oh, he's for the informer. He's
Lordship,
for the informer.
the office note was asked from the Borpeta session judge. That is awaited. This is not the appeal. I have come from the IA, Lordship. The appeal date is already fixed on 29th of January. The appeal has
Oh.
been fixed. This is only for the IA because he's inside for the last 7 years.
then we need to file our objection then.
Lordship, what had happened already, Lordship had passed an order of a co-accused. There also objection was not filed, but
No, you see, it's, so the thing is that I think if the impugned judgment and order is going to be set aside, it will also affect those persons who have been acquitted.
yes, correct. That is
So-
why Lordship waited for them to appear.
But
or at
then,
least notice to be served.
But now, how long are we going to wait for them? It's going to be forever or what?
Not
That is the issue. Now,
Of date, SR
so
is
what we can do is that we can say that the conviction is set aside, judgment is set aside, remand the case back. Additional evidence can be taken in either of the cases, and they should be decided separately on the basis of evidences recorded in that particular case. However, for those persons who have been acquitted, we'll grant them bail. We'll grant them bail because they've been acquitted. Grant them bail, and their fate will be decided by the fresh
By the
decision to be taken by the trial court. Now, with regard to you, the convicted persons,
not.
you apply for bail before the trial court.
The thing is, during pendency, I was in bail, Lordship. And for the last 7 years, during pendency of the trial, I was in bail for the last
So
7
you
years.
can use that as a thing. You can use that as a ground for grant of bail.
Lordship, because the report is awaited and the date is fixed on 29th. Your
So
Lordship
let
fixed the
Lordship
last-
for end of justice. Only few days left. Let the entire matter be taken up on 29th.
And once we cut the tax, the acquitted person now this order has been passed few years back. But when was it passed?
the order of judgment.
No, the order passed by us.
Lordship 15. 15/6/23.
Page 83.
Page 80.
Last time, final rules.
Lordship, during pendency, Lordship, that is what can I at least.
They have got to have, we have got to give them an opportunity
Not,
to file the written objection.
not.
This is the first time it's coming.
Yes, Lordship, first time.
And today is what date?
Nice.
Then 29th is just 20 days away.
Understood.
So, if you all want, we can dispose of the entire thing.
Not today, Manu. Lordship, I don't know if any papers available, please. I don't know who appeared at the last two pages.
I'm waiting for it to be disposed of, but my learned friend.
No, we'll dispose it of on 29th.
That's-
Manu.
As your
Should
Lordship.
we file objection?
Do one thing. You can do one thing. We will give grant bail to those acquitted persons.
But Lordship for a particular period only, otherwise they will not appear and
They will be acquitted anyway again. As per the facts of the case, they'll be acquitted again. But it's only for to follow the procedure. It has to be done. That's all.
If they don't turn up, then would,
If they don't turn up, they don't turn up. Then still it has to be decided on the basis of the evidence that is already recorded. Can't help it. Just because they don't turn up doesn't mean they're guilty.
Lordship, it's a live proceeding. My lord. Nowadays, everyone, Lordship, I think they will not, if your Lordship observation, then they will not, Lordship will decide on that day, 29.
Maybe we should cut off this. Because we can't even,
Express your Lordship.
express our opinion
Yes, ma'am.
freely at times. It can be interpreted in a, wrong manner, in a different manner altogether. Because these are the things that we think.
We have affirmed the conviction but modified the sentence to 20 years from life.